In the particular circumstances of this prosecution, the case is dismissed, and I consider that to be the end of the matter. Mark Donald Eric Keane is before the court in relation to a case that has its origins in the issuing of an infringement notice. The infringement notice was issued on the 16th of October 2018 by Auckland Transport and served by way of ordinary post. The infringement notice alleges that at 3:44 p.m. on 12 October 2018 at Ratanui Street, Henderson, the defendant committed an offence against Rule 6.4 subsection 4 of the Land Transport Road User Rules 2004 and Section 40 of the Land Transport Act 1998 and Rule 4 of the Land Transport Offences and Penalties Regulations 1999, and that the defendant, being the person in charge of motor vehicle registration FAN 394, parked a vehicle in an area marked by a broken yellow line. The defendant, by way of notice in writing, requested a hearing in respect to the alleged offence, as he's entitled to so do. It is noted, just by way of background, that the justices of the peace might ordinarily be the judicial officers who might deal with such a matter. However, in this particular case, there was a ruling made by His Honour Judge Glove on the papers. That ruling having been delivered on the 18th of March last, ordering that at the request of the Justice that the District Court assume the hearing of the matter, that should indeed occur after His Honour having reviewed the file and considering it appropriate that such an order be made pursuant to Section 363 subsection 1 of the Criminal Procedure Act 2011. That's just a long way of saying that it's a case that, whilst not one typically dealt with by a district court judge, has been so dealt with, and that as a matter of law that is entirely possible and appropriate. And so it is that today I have heard the hearing. Ms. Olivia has appeared on behalf of the prosecution for Auckland Transport, and Mr. Keane has represented himself. Although he did not elect to give all call evidence, it is apparent in this particular case that the general facts on which the case relies may not particularly be a dispute. And these are matters I will come back to shortly. But to put it another way, although Mr. Keane did not himself give evidence, it was clear from the evidence that was adduced, both the documentary evidence and the viva voce evidence from the prosecution witness, along with the answers given to questions asked, including under cross-examination, that there was some general common ground in terms of the factual background to the case. Now, Mr. Keane did raise one issue at an early point in the hearing, and that concerns the process by which he came to be the person charged. It being noted that his wife, Leah Brunette, is also noted on the certificate of particulars relating to the registration as a joint person. But I don't intend to go into that matter, as I have already given a ruling with reasons in regard to that issue. The short point there was the Auckland Transport were entitled to proceed against Mr. Keane, and they were entitled to rely on the documentation tendered to the court as demonstrating that Mr. Keane was the registered person responsible for the vehicle. Sufficient for the charge to be brought against him. What I'm now going to be moving to are the more substantive matters that really are at the heart of the case. There's no dispute that the vehicle in relation to which Mr. Keane is registered owner was parked on Ratanui Street at the time and on the day in question. And there's no dispute that there are obligations with regard to the legal parking of vehicles. Land Transport Road User Rule 2004 6.4 subsection 4 or sub rule 4 provides The driver or person in charge of a vehicle must not stop, stand or park the vehicle on any part of a roadway where the road control authority has marked a broken yellow line parallel to and at a distance of not more than 1 metre from the edge of the roadway. I think it's the provision that the prosecution essentially relies on in relation to this matter. The prosecution called the parking warden, Mr. Lamusitelli. I don't intend to traverse all of Mr. Lamusitelli's evidence, except to say that he explained how in the course of his duties he was in Rasanui Street on the day and at the time in question and saw Mr. Keen's vehicle and considered it to be in breach of the rules that I have outlined, or to put it more succinctly, that the vehicle was parked in an area marked by a broken yellow line. Mr. Lamusitelli explained that by the time he had attended to his relevant duties, and I'm paraphrasing his evidence in this regard, the driver had returned to the vehicle and left. And so it was that the notice was duly posted rather than being given to the driver or placed on the vehicle. So it's clear from this that there was no exchange between the driver and the parking warden on the day in question, and one assumes that it was when the notice subsequently came in the post that the issue was brought to, in this case, Mr. Keen's attention. And as I've already noted, Mr. Keen takes issue with what the prosecution is saying in this case, and it's convenient for me to note now what that issue is. And again, I'm paraphrasing for ease of reference. Whilst the court had the benefit of the prosecution photographs showing Mr. Keen's vehicle parked on the day in question, a rainy day, with the photographs having been taken from the footpath, a distance back under the eaves of the District Court building, and as well photographs taken later on a fine day with the vehicle space empty, better showing, the yellow lines according to the prosecution case. The court also had the benefit of seeing photographs produced by Mr. King. And the long and short of all of this is that the photographic evidence shows not only, the court accepts, broken yellow lines, but also white markings in the shape of a parking space. Mr. Keane has referred to these lines as being white hockey stick lines. And it's clear to the court, just to extrapolate from the evidence in hand, that this space has previously been a legal parking space, but the intention had clearly been that change, with a change of markings and the broken yellow lines, then extending into an area that had previously been an ordinary legal parking space. And it's also noted as part of the evidence and not being in dispute that at the rear of this parking area that's been in contention, there's been a sign indicating the availability of parking for a set period of time. And just as the prosecution have, Mr. Keane has also shown with his photographs taken on different dates the space when it's empty, the space when it's got a vehicle in it, and of some interest to the court, more recent photographs showing the blackening out of the white lines, obviously just to make the point to better demarcate what has been intended by the authorities, namely that the space is not an authorised or legal parking space but a prohibited area in terms of parking. While there's been some discussion relating to these matters and evidence given during the course of the case, the court notes the question posed by Mr. Keane along the lines that if there wasn't any confusion about the presence of the white lines, then why is it that these lines have more recently been blackened out? And I simply just note that point and leave it there. It was of further interest to the court that the parking warden, Mr. Lamusatelli, who I want to note gave very careful and considered evidence and was endeavouring to be as frank and helpful as he could be. But he himself, in answer to a question from Mr. Keane, readily conceded that there was misleading road markings in relation to the space in question. That said, of course it's not overlooked that he went on to stress the relevance of the broken yellow lines and what is required of a motorist in that regard, he also endeavoured to explain from his perspective and understanding of the relevant obligations that the broken yellow lines would in any event take precedence. Though Mr. Keenan raised an issue as to the understanding of the parking motorist in that regard, and suggested that where there is misleading signage or confusion, an expectation by the relevant authorities based on their own stated approaches to be taken in a given situation, that an infringement should not be so issued in such circumstances. I simply note these points by way of helpful background because they are helpful in setting out the themes relating to the case. In strict liability offences, once the prosecution has proved the actus reus, which might be understood to be the physical act or omission that forms the basis of an offence, beyond a reasonable doubt, the defendant is prima facie or on the face of it liable. However, a common law defence is available to a defendant to prove that there's a total absence of fault, which must be proved on the balance of probabilities. This defence was discussed in the well-known case of Civil Aviation Department in Mackenzie, 1983 New Zealand Law Reports at 78, a decision of the Court of Appeal. In the case before me, the evidence as to the road markings is, I find, open to the interpretation that it is, or more relevantly was, entirely possible for a driver to have interpreted the space as being within the P90 area, as indicated by the parking sign and suggested by the white marking. That is not, of course, to overlook the broken yellow lines indicating a prohibition from parking. As the offence is a strict liability one, the council have proven the actus reus based on their knowledge of the markings. However, I consider that the defendant has proved an absence of fault to the civil standard, as both the white line marking an available parking space and broken yellow line noting a prohibition in that regard were both present. And on the balance of probabilities, it's likely that the driver considered it to be a legal parking spot, as the white line may have been more visible to the road user, obviously driving in from the roadside, with a finding from me that the white marking is the more noticeable marking from that side, as opposed to the yellow line, which runs along the curb side and is more clearly visible to a person from the footpath area. I note again, even the parking warden agreed in his evidence that the road markings were misleading. And I note again that since this matter came to light, the authorities have now blackened out the white markings to avoid further confusion. In the particular circumstances of this prosecution, the case is dismissed, and I consider that to be the end of the matter.
Thank you very much, Your Honour. Case dismissed. Woo. Auckland Transport will try again next time, eh?